Thank you. Right, I'm Kaele Pilcher, and hopefully you're expecting to hear about the internal dispute resolution procedure. If not, then you're in for an interesting session. Right, so what is the internal dispute resolution procedure? I hear you say. Right, well, as an employer, um, you are required to make a number of decisions during the course of employment regarding the members' service or benefits. So things like when can they actually join the scheme? What contribution band are you going to put them in? If somebody goes on ill health, what level of ill health award are you going to give them? Will you allow somebody to transfer in a different pension after the 12-month time limit? So these are the sort of decisions you have to make. Once you've made your decision, the member needs to be notified of that decision in writing as soon as possible. You're also required to tell them that if they're not happy with your decision, that they can use the internal disputes resolution procedure. So it's there to assist the members if they're not happy with decisions that are being made on their behalf. So hopefully some of you have already been to the discretionary policies webcast that Cheryl did last week. And as part of the scheme regulations, you are required to have written policy for certain discretions, but not all of them. So what I would suggest is with the discretions that you don't have to have a written policy for, but you use on a regular basis, it might be a good idea to have a sort of procedure policy or document that is just for your use on how you are going to action certain decisions. So let's look at the contribution bands the members fall. Well, under the regulations, you have to review everybody's banding every April. That's because the bands increase in April or change in April. So you need to reassess everybody and make sure that they are in the correct band. So depending on the payroll system that you use, it may be that the bands are assessed on a monthly basis by the actual payroll system, and then it will automatically deduct the bands, the contribution percentage for the members, depending on which band they happen to fall that particular month. Or you may set the band for 12 months in April, and that will then stay in place for the next 12 months. But if you do set them in for 12 months, what criteria do you use? How do you decide which band they're going to fall into? And what happens if the members changes their hours during the year? Do you change their bands? Do you leave it as it is? What happens if, like now, we've just had a backdated pay award? Now, if you use the monthly assessment, then you may have some people who have, because of their several months worth of back pay, have gone from one band to the next band up just for that 1 month. And after the pay award has been paid, they will drop back down to the lower band. How are you going to treat those people? Those are the sort of things you need to be putting into a document so that you've got an idea of how you're going to treat people. And then if anybody queries it and says, I haven't been treated fairly because of X, Y, and Z, you've got your policy document there and you can say, I'm sorry, but everybody has been treated like that. Or, oops, we're sorry, we need to do something about that. So it's a good idea for the decisions that you make on a regular basis, even if it is only once a year, that you actually have a document there so that everybody is treated the same way. So, what do you do if you get a member who isn't happy? Well, first of all, talk to them. What are they not happy about? It may be that they've had a misunderstanding. One of their colleagues has told them this will happen or that will happen, when actually that isn't the right thing. So they're basing their decision or their unhappiness on incorrect information that's been received. Try and resolve the issue with the member first. It may be that just by talking to them and explaining that that's it, it's done and dusted, and they're happy. However, if they're still not happy, direct them to our website, where they can find the Internal Disputes Resolution Procedure booklet and the application form. So if you go onto the home page, on the left-hand side of the screen, I think one of the first things on the index is the A to Z. Now, if you click on that and then click on I, the Internal Disputes Resolution Procedure, the booklet and the form are there so that the member can download them and action as necessary. So how does the internal dispute resolution procedure actually work? Well, there's two-stage process. The first stage is dealt with by your adjudicator. Now, I appreciate that small employers may not actually have a named adjudicator because people wear several different hats, but it has to be looked at by somebody at your organisation who wasn't involved in the original decision. So if it was an HR advisor that looked at it, you may want the head of section or somebody else fairly senior to have a look at the case at stage 1. Stage 2 is if the issue isn't resolved at stage 1, it will be looked at by the administrating authority. So, are there time constraints? Yes, there are. The member has 6 months from the date that they are notified of the original decision to submit an IDRP application at stage 1. The adjudicator must write to the member within 2 months, hopefully with a decision. If they're not in a position to make a decision at that stage, they need to tell the member why they can't make a decision and when they expect to be able to make a decision. The member has a further 6 months from the date of the stage 1 decision, so whenever that comes out, to submit an IDRP application at stage 2. So this goes to the administering authority, and their decision must be in writing within 2 months, or if they can't make a decision because they're still waiting for certain information, they have to explain that to the member and tell them when they expect to be in a position to make a decision. So whichever case, stage 1 or stage 2, the member should hear within 2 months. And if they're still not happy after they've gone through stages 1 and stages 2, they can go to the Ombudsman, and it is within 3 years of the original decision that they aren't happy with. So who can apply? Who can appeal? Well, any one of the following: a member or a prospective member, widow or widower of the member, a surviving civil partner of a deceased member, a cohabiting partner, a deceased member's dependents, or members' representatives. Now, under the IDRP, the person is entitled to make an application, can nominate a representative to do the application on their behalf. Now, that would usually be either a union representative or a family member. They can use the representative to make representation at stage 1 and or stage 2 applications. They can also use the representative to continue appeal that has started, should something happen to them. So should the applicant die or become incapable, dementia or something, and they're not mentally capable of carrying out the application themselves, they can still use their representative. So at stage 1, what's the employer looking for? Right, now, first thing, an appeal cannot be considered if there is proceedings through court or for the tribunal. Those have to be dealt with first. But assuming there isn't anything going through the courts or tribunal, then the employer will be considering all the evidence that's been presented, ensuring that the policy procedures have been correctly followed. Now, obviously, that is your policies, your procedures within your organisation. Ensuring that any discretions have been correctly considered and applied, and considering if the correct decision has been made. At stage 2, the admin authority will reconsider the decision, taking account of all the facts and evidence that was submitted or relied on by either party, and will make sure that the decision is the correct one. They will check that the regulations were applied correctly, and they will check that sound impartial procedures were used to reach that decision. So if your procedures are not absolutely fair, then it could well be picked up at stage 2, and that could then come back to you for you to reconsider your procedures. Everything needs to be fair and available for everybody. Okay, now this is particularly important where the employer is using a discretion, that it has to be fair and transparent. If they're still not happy, they can go to the pensions ombudsman. But first, before we run down that route, let's just put things into perspective. The local government pension scheme is the 5th largest scheme in Europe, but only about 140 cases each year actually reach the ombudsman. So that is a very, very low percentage. And more than 50% of those cases are in respect of ill health decisions. And only about 40% of the cases are upheld either in full or in part. So you get as far as the ombudsman, it's going to be, providing everything has been done correctly beforehand, it'll probably get dismissed early on. However, if the pensions ombudsman does make a decision, it is binding on all parties, and you can only appeal that decision on a point of law. So, if one of your cases does get as far as the ombudsman, and you were found to not consider the case correctly or provided incorrect information, either service or pay, to the pension fund, you are likely to be fined for things like distress to the member, various other sort of distress, inconvenience, those sort of things. And the Ombudsman has teeth and will fine you. So, how to avoid the IDRPs? Right. Say a number of complaints that actually reach the Ombudsman are a result of incorrect quotes, because incorrect salary information, incorrect service information is held by the admin authority. So please ensure that your member records are up to date and that contract changes, i.e. hours changes, job titles, anything like that, are reported to us as soon as possible using the record maintenance form through the portal. After all, we're only as good as the information that you provide us. So the other large area is that a number of members who are awarded Tier 2 or Tier 3 believe that their condition is far worse and that they should have been awarded a Tier 1. As you saw from the previous slide, more than 50% of complaints that get to the Ombudsman are to do with ill health. So make sure you keep copious notes, detailed notes of any discussions you had with the member. And obviously, with an ill health case, there is an HR procedure you have to go through, and you have several meetings with that member on the route to an ill health retirement. Make sure you keep notes for every single meeting. Because if it does get to the Ombudsman, they're going to ask you for that sort of evidence. Ensure that your leavers forms retirement notifications are completed on the portal in a timely manner. If you've got somebody who retired 3 years ago and you still haven't given us a retirement notification, I can understand why they're a little bit upset, particularly if they haven't got any money to live on. So make sure you do things quickly. If you send us a leavers form or retirement notification and we've got a query on it, we will email you and ask for further information or for clarification. Please make sure that you deal with these promptly. And finally, talk to your members. We do presentations and we do surgery, so we're here to help you. There is plenty of information on our website. Not that long ago, we did Pension Awareness Week, and the presentations we did are available recordings on the website for your members to look at their leisure. So keep your members engaged. We're not the enemy here. So, points to remember: to avoid complaints in the first place, communication is key. There are a lot of people out there who think that they know what they're talking about. Somebody down the pub, he'll tell you that you can do X, Y, and Z when actually under our regulations you can't. Make sure that you comply with all the legal requirements. Keep yourself on the right side of the law and avoid any delays. Action promptly, because delays will cause complaints in themselves. How to react if you do get a complaint? Okay, we're only human, we all make mistakes. So accept responsibility and don't be afraid to apologise to the member. Keep them on side, keep them sweet, let them know that you are doing your best to help them. Put yourself in the position of the member. What would you want to happen? You wouldn't want to be waiting 3 years for your retirement benefits. And finally keep them informed of the progress that's happening, and when the meetings are, and just let them know what's going on. Don't keep them in the dark. So support is available, obviously, from our contact centre, because it would be usually an employee querying something or complaining about something. So they would go to the contact centre. So there is the website, the email address for the contact centre and their phone number. And then finally, we have a disclaimer, which I will let you read. But has anybody got any questions? Just take yourself off mute and ask, or stick it in the chat box. I'm terribly quiet out there. Either I have confused you all, or it was so clear that you are not going to make any more mistakes and not get any more IDRPs because you're all going to be so prompt with your forms.
That, or they've all gone very shy.
Could be that one.
Any questions? I guess not.
Well, if that's the case, then thank you very much for joining us. This is being recorded, so it will be up on our website in due course, along with the other webcasts of this series. If you've missed any of them, please feel free to go on and have a look at them. And thank you very much for joining us.
Okay, thanks everybody. You're free to leave.